Testing 1 2 3. Testing 1 2 3. This is Radio Free Mormon on the air, broadcasting behind enemy lines. Tonight's episode, Jenn Kamp's own lawyer accuses her of fraud. Yes, just when you thought it was safe to go back into bankruptcy court, something crazy happens again in the Jenn Kamp bankruptcy. And what is happening now is that her own lawyer, specifically and technically her prior lawyer who represented her in the John Dehlin defamation suit, is claiming that she committed fraud. Now, I have just come into possession of a letter written by her former attorney, whose name is Hepworth. And this is a rather lengthy letter. It is written to the bankruptcy trustee in Tacoma, Washington, and it is dated yesterday, October 24th, 2024. Today's date, for the record, is October 25th, 2024. But I managed to get a copy of this letter this morning, and I wanted to share it with you because I think it is that good. It is that important. We are still waiting for the November 7th hearing at which the judge is scheduled to make a final determination on John Dehlin's motion to lift a temporary stay temporarily in order for the damages hearing to go forward in Utah on the defamation case. But while we're waiting for that, this letter has surfaced. And here's a copy of this letter, which I'm going to put up on the screen right now. You can see it is from the law firm titled Hepworth Legal, and they represented Jenn Kamp for approximately 1 year in the defamation case, from around the first part of 2023 to around the first part of 2024, when they were either fired by Jenn Kamp, or which is more likely, I think, that they fired her. They withdrew from representation of Jenn Kamp, and most likely for non-payment of bills, since they are a secured creditor in the bankruptcy proceeding. They are trying to get their attorney's fees back from Jenn Kamp, those that she did not pay them, and those which they secured after she did not pay them. So this is the letter from Hepworth Legal to Michael Malayer, who is the Chapter 13 trustee in Tacoma, Washington, sent to his address in Ruston, Washington on October 24th, 2024. The letter is regarding Jennifer R. Kamp bankruptcy documentation supporting consensual lien. In other words, now Jenn Kamp is trying to get out of this lien in bankruptcy court. And this is a document that it was consensual on her part. It was agreed to on her part. It should be enforced in bankruptcy. And on top of that, Hepworth, her prior attorney, is accusing her of fraud in the way that she went about this bankruptcy. Dear Mr. Malayer, thank you for your inquiry regarding the validity of our firm's lien against Ms. Kamp's property. What property? The house, right? It's the only property she had. We are pleased to provide comprehensive documentation demonstrating that Ms. Kamp explicitly agreed to and repeatedly acknowledged our lien rights against her property. Number one, introduction. Hepworth Legal's lien rights stem from two distinct periods of representation. The March 2023 retainer agreement, which listed Ms. Kamp's home address at 2246 West Surrey Road, Taylorsville, Utah. By the way, I have redacted that address in prior episodes. I see no point in doing that anymore since Jenn Kamp and her husband both live in the same apartment up in Tacoma, actually Gig Harbor, Washington at this point. So they don't live at this address anymore. So I don't see any point in redacting it anymore, which listed Ms. Kamp's home address at that address. On its first page, included her consent to the firm's lien rights. Initially, Ms. Kamp met all payment obligations under the March 2023 retainer agreement, which included her consent to the firm's lien rights. She agreed to it, okay? As litigation costs mounted against well-funded opposition, Ms. Kamp repeatedly promised that payment would come from her property sale. I can't pay you now, but I will gladly repay you Tuesday for legal representation today. Ms. Kamp repeatedly promised that payment would come from her property sale, explicitly acknowledging in writing that, quote, the full balance will be paid as soon as we sell the property and home, period, end of quote. In December 2023, Ms. Kamp terminated representation. So they're saying that Ms. Kamp is the one who terminated the representation December of 2023, just about a year ago. She then orchestrated a rapid divorce proceeding and property transfer in an apparent attempt to defeat the firm's existing lien rights. So you see, all the stuff that Jen's been doing, all the surreptitious and shady stuff that she's been doing, doesn't just affect John Dehlin and OSF. It also affects Hepworth Legal, her prior attorneys, who have a lien. They actually have a secured lien for their outstanding attorney's fees, and it's affecting them. And they are claiming that she did this in order to try and defeat their secured debt against her, which was in the form of existing lien rights to which she had agreed in the initial contract for services that she had signed with Hepworth Legal. The documentation below establishes, number one, the validity of our original consensual lien, and two, evidence that the subsequent property transfer was fraudulent under 11 U.S.C. Section 548 sub A sub 1 sub A. Number two, foundation of lien rights. The basis for our lien begins with the March 2nd, 2023 retainer agreement, which contains an explicit consensual lien provision, which goes as follows. Consensual lien, in addition to any statutory authorized lien, by signing this retainer, you agree to grant the law firm an immediate consensual lien against your present interest in the property detailed below for any present or future services rendered by the law firm left unpaid, including collection costs outlined in Supra, see Exhibit 1, and Exhibit 1 is a copy of the original contract agreement between Jenn Kamp and Hepworth Legal, from which this language is quoted. She signed it, she read it, she agreed to it. While the specific property address was not included in the agreement, subsequent communications repeatedly confirmed that Ms. Kamp understood and intended her home and property to be subject to our lien rights. Utah courts have consistently held that such subsequent communications can establish the specific property subject to a consensual lien. Additionally, in another case, the Utah Supreme Court held that substantial compliance is sufficient for lien validity where essential information is provided through other means. Hepworth's lien, that's the attorney, Hepworth's lien is further supported by this other case that's named there, which specifically addressed consensual liens and held that a plausible good faith basis for claiming a consensual lien is sufficient. The court validated liens based on contractual arrangements, even without strict statutory compliance. So it sounds like what Jenn Kamp's trying to do is get out of the secured lien by saying that her property address was not included in the original contract, and that's why they're making this argument that it doesn't have to be. It can be supported subsequently by subsequent communications. Importantly, our case is distinguishable from Wren versus Christensen, where the court invalidated a lien based on retainer language, merely stating the attorney was entitled to a lien under Utah law. Our retainer contains explicit words of consent, creating an immediate consensual lien, not merely a recitation of statutory rights. Okay. Number three, clear identification of property subject to lien. While the consensual lien provision in the retainer agreement did not specify a property address, Ms. Kamp's home at the address in Taylorsville was clearly identified on the first page of the same document. This address identification, combined with Ms. Kamp's subsequent acknowledgments that her home would secure payment, eliminates any ambiguity about which property was subject to the lien. Then they cite another case for the proposition that such identification is more than sufficient to establish the property subject to the lien. By the way, when it comes to these long case names that are cited, I typically don't read those because they get in the way of the flow and they don't really add anything as far as getting the message across to the listener. The Utah Supreme Court has consistently held that property descriptions need not be perfect. In this certain case from the Utah Supreme Court, the court held that describing more property than actually subject to the lien does not invalidate the lien entirely. Our documentation shows clear property identification through multiple communications. Here, Ms. Kamp's communications leave no doubt about which property was subject to our lien rights. The first communication they list is from November 3rd, 2023, email from Ms. Kamp, quoting, "We are in the process of subdividing our land and selling everything. The full balance will be paid as soon as we sell the property and home." A November 22nd, 2023 text from Ms. Kamp, "We are out of money as it stands. We are in the process of subdividing our land. Usually takes a month or two for this process. and will list both properties to sell as soon as the plat is recorded with the state. Then you will be paid in full as they sell. We will have a lot more equity than what we owe you by that time. A November 27th, 2023 text is quoted from Jenn Kamp. Please know that Jason and I are selling our home and property to fund this lawsuit. This is everything to us because we feel so deeply in the harm this organization and John Dehlin will cause others in the post-Mormon community. Then there's a December 5th, 2023 text providing specific property details. Quote, we only have our farm here. Once again, this is from Jenn Kamp to her attorneys at the time. We only have our farm here. When we subdivide, we will have one 1-acre lot and 1.5 acre lot that includes our home. She further specified values. Quote, we will list around $500,000 for the lot. The equity in the other lot / house is probably $200,000. They quote a March 9th, 2024 text explicitly acknowledging our lien rights from Jenn Kamp. Quote, you know you will be paid. You could at any time put a lien on my house if you felt I would not pay what is rightfully due as soon as the house is sold. Okay, I think that's getting closer to the mark now, where she's acknowledging that they can put a lien on her house. Hepworth Legal can put a lien on her house if they want to. Well, apparently it's their right to according to the contract. But this is further evidence that she acknowledges what's in the contract and that it relates to her house and her property specifically. June 25th, 2024, there's an email from Jenn that is quoted in part, I am asking you to remove the lien off Jason's home right away. So between the March 9th and the June 25th email in 2024, apparently they went ahead and they put the lien on the house. And she emails them saying, I am asking you to remove the lien off Jason's home right away. Remember, she owes them around, what is it, $80,000 to $90,000? I can't remember the exact amount, but she owes them a substantial sum in unpaid attorney's fees. So in March 9th, she says that they can put a lien on the house. And in June 25th now, March, April, May, June, 3 months later, she's asking them to take it off the house. I am asking you, Hepworth Legal, to remove the lien off Jason's home right away. Once again, Jason is her husband from whom she was getting this divorce, right? So now she's saying it's Jason's home because she had quitclaimed it to him, remember? I am asking you to remove the lien off Jason's home right away. He is not on our contract, and the equity in the home is fully his and not subject to this debt. Oh, she's playing with fire. She's saying Jason's name is not on the contract that I have with you, Hepworth Legal, and my name is not on the house anymore. It's fully his. So I'm asking you to take your name off of Jason's home or your lien off Jason's home right away. Later that same day, she replies, quote, I don't hold equity in our home by a legally bound document with Jason. I think she's talking about the quitclaim deed. You can't lien against a home where I hold no value / equity legally. How would you like to proceed? You will get nothing from the home, period. End of quote. Wow. Jenn Kamp has been playing some games with her prior attorneys, hasn't she? On June 28th, 2024, there's a text from Jenn Kamp that gets quoted here. Everyone is already aware of your lien. It obviously will be paid when Jason's home sells the last day of July. Everyone is aware of it, period, end of quote. The letter goes on. Under this particular case, where a general waiver is executed and there's nothing in the contract to show a contrary intention, there is nothing left for the court to do but enforce the contract as the parties have made it. Similarly, Ms. Kamp's repeated acknowledgments of our lien rights should be enforced. Number 4, contractual basis for interest rate. The 24% interest rate, excuse me, the 24% interest rate, holy crap, applied to Ms. Kamp. That's high. That's the reaction you're getting from me. That's why. The 24% interest rate applied to Ms. Kamp's outstanding balance is contractually authorized and actually represents a reduction from the agreed upon rate. So apparently there's some argument over this 24% interest rate. A, contractual authority. The March 2nd, 2023 retainer agreement explicitly provides all invoices become due upon receipt. All unpaid balances will accrue interest at 25% per annum. B, application of interest rate. The firm has exercised billing discretion by charging 24% rather than the contracted 25%, consistently documenting interest calculations, providing regular statements showing accrual, allowing reasonable time for payment before interest began accruing. Number 5, important context regarding late 2023 communications. You may notice some communications from late 2023 discussing potential additional liens or security agreements. For clarity, by December 2023, Ms. Kamp had accrued substantial fees, approximately $55,678.07, approximately though, and 7 cents, and requested that we continue representation despite the mounting balance. We discussed extending her a significant line of credit for future fees, approximately $100,000. That's because they got the lien on the house, right? Which would have required additional security documents. These discussions were separate from and did not affect our existing lien rights for past due fees under the original retainer agreement. While these negotiations ultimately proved unsuccessful, their existence demonstrates A, Ms. Kamp's clear understanding that her property could secure legal fees, B, her repeated acknowledgement of our right to secure payment with her property, and C, her consistent intent to pay our fees from property proceeds. Number 6, subsequent actions confirming understanding of lien. Ms. Kamp's recent actions further demonstrate her longstanding understanding of our lien rights. A, September 23rd, 2024 text. This is recent. This is last month. Attempting to limit the lien scope. Quote, can you please amend your motion to say that you only have a lien on my half of the property in Utah? Period. End of quote. This shows recognition of the existing lien, understanding that the property was always subject to our rights, and an attempt to retroactively modify the scope rather than challenge the fundamental validity of the lien. So if she's trying to modify the scope of the lien, she's implicitly recognizing that there is a lien that exists that predates her effort to modify it. Otherwise, there would be nothing to modify. And she's not challenging the validity of the lien. She's trying to modify the lien. B, property transfer timeline. March 9th, 2024. Promises house will be listed April 1st and assures payment. Pre-bankruptcy. Executes quitclaim deed to Jason. July 15th, 2024. Divorce decree acknowledges $98,000 debt. I was low. It's a $98,000 debt. It's probably accrued interest. But a divorce decree acknowledges the $98,000 debt while attempting to shield assets. So this is a substantial bill that she's run up with her prior attorneys that they are trying to collect through their lien on her house, and she's trying to avoid that debt and avoid paying them back. Number 7, legal authority supporting lien validity. Please see Appendix A for a list of key cases support the validity of our lien. And now we get to a really, really interesting part, the part that had me title this podcast, Jenn Kamp's own lawyer accuses her of fraud. Once again, this is technically a prior attorney who did represent her for approximately a year in the defamation suit against John Dehlin. This is the person, this is the attorney writing this letter to the bankruptcy trustee in Tacoma, Washington about Jenn Kamp, his former client. 8, evidence of fraudulent transfer. The evidence overwhelmingly demonstrates that Ms. Kamp orchestrated a calculated scheme to defraud creditors through a manufactured divorce proceeding and artificial debt obligations, precisely the conduct that 11 U.S.C. is designed to prevent. A clear pattern of intent to defraud. The evolution of Ms. Kamp's conduct reveals her fraudulent intent with striking clarity. Number 1, initial phase. By the way, number 1 is the initial phase, open acknowledgement of the debt. Number 2 is the transition phase, implementation of fraudulent scheme. And number 3, culmination phase, rapid execution of transfer. Let's go into those 3 in detail. Number 1, initial phase, open acknowledgement of debt. This consists of the following facts. November 3rd, 2023, explicitly promises, Jenn Kamp does, The full balance will be paid as soon as we sell the property and home, quote unquote. November 27th, 2023, she confirms, quote, Jason and I are selling our home and property to fund this lawsuit. December 1st, 2023, Jenn acknowledges specific debt of $50,110.26, requests final review of invoices. Now, number 2 is the transition phase, the implementation that Jenn Kamp did, according to this letter written by her former attorney, implementation of fraudulent scheme. On May 28th, 2024, that's this year, after the payment demand, which would be by Hepworth Legal upon her, Jenn Kamp suddenly claims unspecified discrepancies. June 6, 2024, Jenn Kamp begins delaying tactics through payment plan requests. So she begins requesting a payment plan from Hepworth Legal by which she can repay them the amount that she owes them. They're calling this a delaying tactic now in hindsight. That started June 6, 2024. On June 7th, 2024, the following day, Jenn Kamp demands mediation while secretly preparing divorce filing. So she wants to go to mediation about the amount of money she owes Hepworth Legal, but she was secretly preparing a divorce filing. Absolutely, she was. June 11th, 2024, Jenn Kamp, that's 4 days later, Jenn Kamp files her divorce petition without notice to creditors. On June 25th, 2024, Jenn Kamp reveals her scheme by claiming, quote, I don't hold equity in our home, period, end of quote. This is what's going on from Hepworth Legal's point of view. And these are the steps that she has taken in order to defraud them. 3, culmination phase, rapid execution of transfer. On July 12th, 2024, she files her financial declarations, which I think would be in bankruptcy court. She filed in bankruptcy over the 4th of July weekend. On July 12th, 2024, Jenn Kamp files her financial declarations. On July 15th, 2024, she obtains her divorce decree. And on July 31st, 2024, she coordinates the sale of her property. That was a very busy month for Jenn Kamp. Now, B, Section B, direct evidence of fraudulent intent. Ms. Kamp's own words on June 28th, 2024, inadvertently expose her scheme. Here's the quote. Everyone is already aware of your lien. This is Jenn Kamp to Hepworth Legal. Everyone is already aware of your lien. It obviously will be paid when Jason's home sells the last day of July. I owe Jason. Now, once again, it didn't sell on the last day of July. That was obviated by the trustee when he found out that she was trying to sell assets out from under the bankruptcy court. Okay. But that was the plan. It obviously will be paid when Jason's home sells the last day of July. I owe Jason $299,000 before the amount I will owe him for this payment to you now. That's almost $400,000 that he has had to pay. And that's the end of the quote from Jenn Kamp's message. This remarkable admission reveals, Hepworth Legal goes on, this remarkable admission reveals 4 things. Number 1, full awareness of creditor rights. She knows that she owes this money to Hepworth Legal. 2, deliberate attempt to defeat those rights. 3, creation of artificial debt to absorb equity. So what I think he's alleging there is that she's creating this artificial debt of $400,000 that she says she owes to her husband in order to absorb the equity out of the house and pay it to him, right? Before she pays it to any of the creditors, including Hepworth Legal, her prior attorney. And 4, coordination with an insider to shield her assets. The insider is Jason, her husband. And obviously she's been coordinating with him to shield her assets. In other words, I owe Jason all this money, this $400,000. So he gets the money. Sorry, all you creditors, you don't get the money. And now we just end up living in the same apartment in Gig Harbor. Well, we're really divorced, but we're just living together for now. Yeah, nobody's buying this, Jenn. Nobody's believing this. And now your former attorney is having to come after you because you are trying to stiff him for his legal fees that you agreed he could have a lien on your property for. C, statutory analysis. Once again, back to the letter under 11 U.S.C. Pursuant to 11 U.S.C., and there's the citation, quote, The trustee may avoid any transfer, and that means void it, get rid of it, reverse it, undo it, unwind it. The trustee may avoid any transfer, including any transfer to or for the benefit of an insider under an employment contract, of an interest of the debtor in property, or any obligation, including any obligation to or for the benefit of an insider under an employment contract. So what he's saying is that pursuant to this section in the 11 U.S.C., what you can do, judge and trustee in the bankruptcy court, is you can unwind any alleged debt that she says that she owes to her husband, who's the insider. And it goes on to talk about the conditions under which you can do that. And apparently there's a 2-year look-back period there. Furthermore, in determining actual intent, consideration is given to the following factors. 1, the transfer or obligation was to an insider. Yes. 2, the debtor retained possession or control of the property transferred after the transfer. Yeah. 3, the transfer or obligation was disclosed or concealed. Yeah, it was concealed until the other side told the trustee about it in bankruptcy, and then they revealed it. Number 4, before the transfer was made or obligation was incurred, the debtor had been sued or threatened with suit. Yeah. 5, the transfer was of substantially all the debtor's assets. Yes. 6, the debtor absconded. 7, the debtor removed or concealed assets. 8, the value of the consideration received by the debtor was reasonably equivalent to the value of the asset transferred or the amount of the obligation incurred, which just means that if you're actually selling something or transferring something to somebody else, if it's legitimate, you're going to try and do it for the value of something that you received in exchange for the property that you're giving. You're not going to pay somebody $100 to do something for you or sell you something unless you think it's worth $100. If you give away a piece of property that is worth, let's say, $100,000 to somebody else, but you only get $10 back from it, obviously something's going on. The debtor was insolvent or became insolvent shortly after the transfer was made or the obligation was incurred. Yes. 10, the transfer occurred shortly before or shortly after a substantial debt was incurred. Yes. And 11, the debtor transferred the essential assets of the business to a lienor who transferred the assets to an insider of the debtor. And there's a citation for that 11-prong analysis. In this case, the letter goes on, in this case, multiple badges of fraud and direct evidence strongly indicate that Ms. Kamp's transfer of property through divorce proceedings constitutes a fraudulent transfer intended to defeat creditor rights. Yeah, you think? The most significant indicator of fraud is the transfer to an insider. Ms. Kamp transferred the property to her ex-husband, Jason Kamp, through an expedited divorce proceeding filed immediately after receiving final payment demands. The timing of this divorce filing, coupled with the subsequent rapid progression to decree, strongly suggests the divorce was strategic rather than genuine. Importantly, upon information and belief, Ms. Kamp retained possession and control of the property after the transfer, maintaining involvement in the sale process and remaining in possession even after the transfer was complete. Yes, she did. The planned July 31st, 2024 sale date, coordinated under her continued involvement. She's involved in the sale, which she wouldn't normally be if she'd actually transferred this property to somebody else in a legitimate way. Further evidences her ongoing control of the property. The timing of the transfer relative to Ms. Kamp's substantial debt is particularly telling. She executed the transfer immediately after receiving significant payment demands, filing for divorce shortly after final collection attempts, and subsequently filing for bankruptcy. So this is all the stuff that's been going on between Hepworth Legal and Jenn Kamp, stuff I didn't know about before, stuff I haven't reported on before. But from their point of view, they've been going after her for the money that she owes them, and finally gotten to the point where Hepworth Legal is sending her final collection attempts, and then she files for divorce shortly after those financial collection attempts begin, and then shortly thereafter filing for bankruptcy. This sequence of events strongly suggests a calculated effort to shield assets from the firm's lien. Moreover, the property represented substantially all of Ms. Kamp's assets, as evidenced by her own admission that, quote, "we only have our farm here." By transferring this property, she effectively stripped herself of her primary asset available to creditors. Perhaps most revealing is the lack of adequate consideration for the transfer. That's where you talk about the money that you got in exchange for the thing that you sold, right? We talked about that before. Ms. Kamp attempted to justify the transfer by claiming a $299,000 debt to Jason, but no evidence supports the legitimacy of this obligation. She has no evidence to show that she actually owed $299,000 to Jason. She just says so. Her June 28th, 2024 email inadvertently reveals the manufactured nature of these obligations, referring to, quote, almost $400,000 that he has had to pay, unquote. This artificial debt appears designed specifically to absorb any equity that might have been available to creditors. Yeah, why is it that she says in one place she owes Jason $299,000, but then she immediately thereafter says almost $400,000 that Jason has had to pay for her attorney's fees? Okay, yep, it does look artificial. You've got a point there. The chronological development of events provides compelling evidence of fraudulent intent. Initially, Ms. Kamp openly acknowledged her debt and promised payment from the property sale, as demonstrated in her November 3rd, 2023 communication. However, her approach shifted dramatically in mid-2024. She began employing delay tactics, requesting meetings about discrepancies, suddenly seeking a payment plan, and demanding mediation while secretly preparing divorce filings. This progression culminated in the rapid sequence of her divorce filing on June 11th, 2024, financial declarations on July 12th, and divorce decree on July 15th, all coordinated with a planned July 31st property sale. Ms. Kamp's own communications provide direct evidence of fraudulent intent. Her June 28th, 2024 statements acknowledge awareness of the lien while attempting to defeat it through the transfer to Jason. She referred to the planned sale of Jason's home while creating an artificial debt structure designed to absorb any viable equity. These communications reveal a calculated scheme to shield assets from legitimate creditors through a manufactured divorce proceeding and artificial obligations. Based on this evidence, the transfer should be avoided or undone as fraudulent under Section 548 of the Bankruptcy Code. The presence of multiple badges of fraud, the suspicious timing and sequence of events, the lack of legitimate consideration, and Ms. Kamp's own admissions collectively demonstrate actual intent to hinder, delay, or defraud creditors. The trustee should seek to avoid this transfer from her to Jason and preserve the asset for the bankruptcy estate. Ms. Kamp's transparent attempt to defeat creditor rights through a manufactured divorce proceeding and artificial debt obligations exemplifies precisely the type of conduct that fraudulent transfer laws are designed to prevent. Number 9, relief requested. We respectfully request 1, recognition of our consensual lien based on the original retainer agreement, clear course of dealing in identifying property, and Ms. Kamp's repeated acknowledgments of the lien. Number 2, investigation of the apparent fraudulent transfer scheme. So Michael Hepworth is also asking the trustee to investigate the apparent fraudulent transfer scheme. 3, preservation of our right to pursue transferred property. And 4, alternative relief should any technical aspect of our lien documentation be questioned. This case from Utah supports our right to equitable subrogation or alternative relief based on the parties' clear intentions and course of dealing. We are prepared to provide additional documentation or briefing on any aspect of these issues. Sincerely, Michael K. Hepworth, attorney at law from Hepworth Legal. That is a 6-page letter. There are 12 pages to the entire submission. The balance of the 12 pages are exhibits. Exhibit 1 is the contract for services between Hepworth Legal and Jennifer Kamp entered into on March 2nd, 2023. Apparently, the hourly rates for Michael Hepworth are $425 an hour. Holy crap, I've got to raise my rates. The retainer was $7,500 initially, and so forth, and it's quite lengthy. It goes on for a number of pages. signed by Jennifer Kamp on March 2nd, 2023, in which she acknowledges that she received a copy of this agreement, that she had read and fully understood each and every term of this agreement, and that she agreed to each and every term contained in it, and she understood that she was entering into a contract between the law firm and herself. And then Appendix A, which is a little bit weird, because they went from Exhibit 1 to Exhibit A. That's a little unusual, but these things happen. And that's his table of authorities for the argument that he's making. Okay, so that is the letter from yesterday, October 24th, 2024, from Jenn Kamp's prior attorney, Michael Hepworth, to the trustee in the bankruptcy case, accusing Jenn Kamp of committing fraud, showing exactly how she did it, and that she's trying to defraud her prior attorneys out of their legal fees in spite of the lien that they believe they have and are justified in having on her property. They want the trustee to investigate this fraud. They want the trustee to reverse this transfer that she says she made of the equity in her property to her husband, Jason, for Jason making all of these payments to her so she could pay her attorney, payments that have not been proven but are only alleged by Jenn Kamp. So this case just keeps getting more and more interesting. We'll have to see what happens as a result of this letter and this request to the trustee, while still keeping our eyes on the date of November 7th and seeing what the judge is going to do there about the request by John Dehlin and OSF to temporarily lift the automatic stay so they can go back to Utah and have the damages hearing there in front of Judge Faust. This case continues onward, and it doesn't look like it's going very well for Jenn Kamp in bankruptcy court in Tacoma. Well, that's about all I have for you tonight. Please hit like, please hit subscribe, please leave a comment below to let me know what you think. And also, I want to thank all of my wonderful listeners who have gone the extra mile and have gone to radiofreemormon.org and made a donation there. If you would do so, if you haven't already, I would greatly appreciate it. Thank you so much for watching. Until next time, this is Radio Free Mormon, signing off the air.